All right, we'll go back on the record. In this case, I have considered the defendant's objection to retaining the jurors for possible use in the sentencing phase in the event that there was an emergency or an illness by one of our jurors. And I believe the case that was cited, one of the cases that was cited was State versus Bobo, and that was a 1991 Tennessee Supreme Court decision, as well as the rule that's been cited. And I believe you have one more case. I didn't write that one down, so I apologize. But I'm referring to and relying upon State versus Hester, State versus H.R. Hester, which is a 2010 Tennessee Supreme Court decision. In that case, Senior Judge Alan Wallace was the presiding judge over a death penalty case, and in that case, he retained some of the alternate jurors for possible use in the event that some of the jurors during deliberation became ill. Sure enough, one of them became ill during the sentencing phase. Judge Wallace replaced that juror with one of the alternates, and the case went forward. That was appealed to the Court of Criminal Appeals. It was his actions were affirmed, and then the Supreme Court dealt with it, and I'm just going to quote the language of that decision regarding that particular issue and show why it is instructive in my use. Finally, Mr. Hester argues that the trial court's replacement of the stricken juror with an alternate juror violated Tennessee Rule of Criminal Procedure 24F2B. This rule states that alternate jurors in the order in which they are called shall replace jurors who become unable or disqualified to perform their duties prior to the time the jury retires to consider its verdict. An alternate juror who does not replace a regular juror shall be discharged when the jury retires to consider its verdict. This is the language of the Supreme Court. By its own terms, this rule does not clearly apply to the replacement of a juror in the context of a bifurcated capital case. In the context of such proceedings, there are, as ably noted by our judicial colleagues in other state courts, essentially two verdicts, one for the guilt phase and one for the question of sentencing. We find no error in the trial court's decision, which ultimately was shown to be prudent, to not discharge all of the alternate jurors prior to the commencement of deliberations by the jury following the sentencing hearing. So that's State versus Hester, 324 Southwest 3rd, page 1, and then again on page 67 is the page that or the section I've quoted, and it's the Tennessee Supreme Court decision from 2010. Following my research and my interpretation of that case law, this court is of the opinion that I am on firm ground in retaining these alternate jurors. Hopefully that will not be an issue that we'll ever have to deal with, but in the event that it is, my intent is to have them available and to avoid any problems if there were to be an emergency in the 12 that we have. Then we would have alternates that can be used to replace them as approved by our Tennessee Supreme Court in that decision. So that is my ruling upon that. I note the defendant's objection, and that's an issue that will be preserved. Thank you. Anything further than before we recess pending the return of the jury? We stand in recess pending the return of the jury.
All right. This court is in recess.
Recording stopped.